Case number 21CR76, State of Ohio versus Geneva L. Davis. Present for the state is Assistant Prosecuting Attorney King, present for the defense Attorney Danielle Witt, for Geneva L. Davis.
Yes, sir.
Ms. Davis has entered a plea of guilty to aggravated possession of methamphetamine, fifth degree felony. The court ordered a pre-sentence report, and I will confess I really haven't had a chance to look at it. I do see here that Lynn Goff indicated that there's a bed available for her on the 29th of November. So I'll take a quick hand at it. After the attorneys both received a summary.
Say that again.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only was he made for your
Ms. Witt?
Yes, Your Honor. We asked the court for community service for Geneva. She has a long-standing problem with meth, and as you mentioned, there is a bed available for her at Lindolph. It's her understanding, though, it's available on Wednesday, what she's told me.
Oh, this Wednesday?
Yes.
Oh.
And we just asked the court for community control and feel that she would be amenable to that.
All right. Ms. Davis, anything you'd like to say? I'm looking at your report that back in 2020 you were indicted in Hamilton County on a first degree felony and a second degree felony, fourth degree felony. What happened to those cases?
I was court on December the 7th.
Okay, so those are still pending? Okay, December the 7th? Okay, geez, what happened March of 2020? Of course, I suppose with COVID, I know that Hamilton County is one of the last counties to start back up operations. So. Well, I would imagine that with those aggravated trafficking and aggravated possession, that there may be mandatory time there. So, if you're convicted of that, I believe that you would be sentenced to a term of imprisonment because it's required by law. But I'm going to go ahead and grant you control of discharge, and that'll be for a period of 3 years. Now, the conditions of the community control are that you obey all laws of all jurisdictions. Now, since these other cases are already pending, if you are convicted of them, they will not be a violation of community control in this case. But if you get a prison term out of that, then the 3 years of community control will stop while you're serving your sentence, and then once you get out of prison, you'll be required to report immediately to the probation department. Now, you'll be required to conduct yourself in a law-abiding manner at all times. You must report when and as directed. You must be truthful in all statements that you make to the probation department, supervised officers, as well as any answers to questions that they ask you about your conditions. You must keep them informed of your residence, place of employment at all times. You may not change, you may not change without permission of your supervised officer. You may not leave the state of Ohio at any time without prior permission. If you do, you must have that pass with you times to travel state. You're not permitted to enter upon grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. And because of your conviction in this case, For this offense, you are prohibited under both federal and state law from purchasing, possessing, owning, using, or having under your control any kind of firearm, ammunition, or dangerous ordnance. And if you were to do so, then that would subject you to being prosecuted for a felony under either state or federal or federal law. Now, it's also a condition that you're not having those items or any other weapons of any type while you're on community control in this case. You're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has any effect similar to controlled substances or drugs abuse, or any instrument, device, or thing that may be used to administer them, or prepare their administration, except those for which you have a lawful prescription. You must provide a copy of that within 24 hours of receipt. You're to submit to drug testing when it is directed. May not purchase, possess, use, or have under your control any kind of an alcoholic beverage, nor may you be present in places where the sold or being consumed, even if otherwise lawful. You're not permitted to associate with anyone who's a co-defendant in this case, or if there were any, I don't think there were, or any other persons who have criminal records, a member of a gang or a criminal group, or any person who has in the past committed future collection, committed a criminal offense, or violate these conditions, unless approved in writing by your supervised officer. That will also apply to your family members if there are any that fit that definition, that you were living with them immediately before the commission of this offense. Now, obviously, it doesn't apply to your being involved in golf or any kind of group sessions and so forth for treatment. Now, you're to report any contact law enforcement for any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. So once you have keep the probation department informed of what's going on in your Hamilton County case. You must provide your probation officer with financial information records or your ability to pay any fines, fees, or costs of your review. If you're referred for any further evaluation or assessment or any kind of programming or treatment beyond that that's ordered by the court, in order to undergo that evaluation, if they recommend any kind of programming, then you're to enroll in and successfully complete that. You pay the court costs of this action, make payment arrangements to do that. You're successfully complete Lynn golf, and you said there's a bed available for you the day after tomorrow, because they just gave us a notice that it was 29, so apparently they've got something open up. They did confirm that to you, Mr. Roger, in the contract. All right, so you're to successfully complete Lynn golf. Treatment program and any aftercare. Now again, should you be convicted and sentenced to prison, that's interrupted, then once you get out of prison, for probation, they'll determine whether or not you need to go back in and finish it, or if there's been something that's happened that would suffice. But for now, that would be the order of the court and any aftercare. So once you get done with the group, take off your problem there, sir. Sorry. Now, by being placed on community control rather than being sentenced to prison, you're deemed and consented to a search without a warrant of your person, residence, vehicles owned by you, or used by you, or any other property places under your control where you're found at any time by any officer of the probation department. I'll not impose any fine, or will not impose any driving suspension. The court costs are ordered to be paid, and if you don't make payment arrangements as ordered as a condition, then the clerk of court can collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then you can be ordered to do community service and be given credit for each hour you work in an hour already set by the court. And each hour you work will reduce your judgment by that amount until the pay is full. Now, in the event that the probation department feels that you have failed to comply with these conditions, they will file a notice of that with the court. You'll be given a copy of that. You'll be entitled to have a hearing and be represented by an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court will revoke community control and sentence you to a prison term of between 6 and 12 months and fine you $2,500. If that occurs, then once you complete that prison term, it is possible, as an option of the adult parole board, if they could put you under police control supervision for a period of up to 2 years. They don't have to, but they could. If they do, you'll be supervised by a parole officer on the terms of the parole board sets, and during that time they determine that you have failed to comply. They can return you to prison if you serve an additional period of up to, in this case, half of your prison term. for one or more violations of that coach release control. However, should you commit a new felony while under coach release control, then in addition to whatever sentence the judge in a new case can impose on you, the judge is also authorized to sentence you in this case for an additional period of 1 year, whatever time's left on that, up to 2 years of coach release control. Generally is greater or more. If that occurs, that we serve consecutively the sentence in the new case. All right, is there anything further, counsel? What time do they want her, are you gonna take her down there probation, or are they gonna come get her what?
I'm not sure.
All right, let's check on Mr. Arjima, you have to get yourself down there, or perhaps on leave at probation. But, usually it's between, I think,
I think it's 9 o'clock.
okay, I'm gonna say usually between 8 and 10. All right, okay, so I'm gonna put in here, report 11:22, oh, I'm sorry, 24 at 9 a.m. All right. All right, I think it's then, see Mr. Arjima over there, and, we'll go from there in terms of the lead report.
Thank you.
All right, Thomas Manry. Any others you got? Okay, how about, what's your name, sir?
Paul Cruz?
Okay, you're here for 1:30?
Yes.
All right. Are you with him, sir?
Yes, sir.
Okay. All right, well, let's go ahead and do this case then. Let's see, it's not here yet.
Your Honor, do you mind if I have a moment to speak with him?
Okay. Katie Creed is also on the docket, I believe. For the bottom of your screen, and has a mic with a red, it's red with a line through it. If you click on that, that'll be, say, unmute. And it also needs you to start your video. I know if you're on a phone, there should be a button there. You have to scroll down to the bottom and push on share video or start video, something to that effect.
Yeah, I
All
got
right,
it.
great. There we go. All right, she's here. All right, this is case number 21 CR 177. They allow Katie Marie Creek. You're Katie Marie Creek, right?
Yes, sir.
All right, well, we're doing you by video, and your attorney is Daniel Wood. She's present here in court. We've got another area of the persons that are here in person to do, so rather than have her scramble somewhere, we're going to do it this way. The assistant prosecutor, Mr. King, is also present. It's previous charge with one count of aggravated possession of methamphetamine, a fifth degree felony. This is a first degree trial, I believe, jury trial set for the 15th of December, and a jury trial set for the 11th. All right, now, I see that the state provided discovery. You have that is with,
Yes, Your Honor.
and your discovery is due, I don't see it, it's due by final pre-trial, and can you anticipate any pre-trial motions?
No, none at this time.
All right. And has been a written plea offer provided?
There has.
Okay. Have you been able to talk to your client about it?
No, not yet. I just need to verify a good phone number for her as well.
All right. All right, now, all right, Ms. Creed, are you still at 619 Gibbs Avenue?
Yes, sir.
All right, and your attorney needs a good phone number to contact you. What is it?
513-383-1930.
Okay. Okay, I see that you have tested positive for meth on the 9th, and what was admission that day, you admitted you had, and then on the 16th, you tested positive for that as well as ecstasy and amphetamines. You're enrolled at Southern Valley Mental Health, as I understand it, courthouse.
Yes.
Well, you need to get to the SPARS up there, Pickaway Area Recovery, which is state recovery, and get evaluated for substance abuse issues if you have another test. So you continue to report. It says you're compliant, so you're going to get tested the next time you come in. If you're positive again, they're going to probably refer you. I'd say that given the nature of the charge, you probably ought to go ahead and do that on your own.
Yeah, we were talking about it.
Well, I'd say time to talk is past. I think time for action now. So, yeah, take care of that. All right, we'll see you then. Our next pre-trial will be December 15th at 2:15. That'll also be budget.
Okay, sir.
Thank you.
Thank you.
All right, now, you can go ahead and log off.
Okay.
Now, there has been a Zoom hearing sent out from Mr. McCray. So let me call that case, and then we'll go to case number 21 CR 126, State 100 versus Thomas R. Henry. Present on behalf of the state, Mr. Prosecutor King. We have the defendant's attorney Daniel Witt. Mr. Henry is not present. Now, just looking here that we did have a pre-trial September 22nd. And I set that for today in person. And then there was a Zoom invite set out. Not quite sure why. But it is now 1:28. Mr. Manning is not present in person, nor by Zoom. Ms. Witt, have you had any communication with Mr. Manning?
I have not, Your Honor, since the last pretrial.
Has he been reporting?
Yes, he was in the office last week after he spoke to the prosecutor.
Your Honor, he was in our office last week on the 15th for his version interview. He completed it, said he was going to probation as soon as he left our office.
And he did.
All right. Well, what I'll do is I'll you can get in touch with him. And is he scheduled to come in anytime this week?
Today, after court.
Okay. Well, both of you call him and see if you can get hold of him, and if you can, we'll reschedule this for, we need to get in touch with you and find out what's going on. But if you guys don't hear anything, come in by 4 o'clock tomorrow. And we'll get you a cake. All right. Thank you. All right, Mr. Rude. Close this out. We'll see the 2 o'clock, was that in person or Zoom? Now, these are used. I haven't touched it at 2 o'clock. All right, case number 20 CR 100, State of Ohio versus Paul Henry Cruz. Present for the State of Ohio is Assistant Prosecutor King. Also is representing probation department, there's Officer Argila, and then is represented by Attorney Daniel Witt. And you are Paul Henry Cruz?
Yes, sir.
evidentiary hearing last week. Defendant entered a plea guilty to aggravated possession of drugs and a 53 felony, and was placed on intervention in lieu of conviction on September 2nd, 2020. Now, there was a notification filed on November 5th, 2021, indicating that the defendant had been charged in violating Rule 1, in that he had been charged in Claremont County operating a vehicle under the influence of alcohol or drugs, and Officer 21, pled guilty. Rule 9, that he was cited in municipal court on August 21st of 2021 in Claremont County Municipal Court, and failed to notify probation of that contact. And then on the 24th of September, he was taken into custody and appear, and was released on September 29th. And it wasn't until that time that the defendant admitted to having contact. And then Rule 11, the defendant tested positive for THC on May 4 and 20th, June 11th, July 8th, 2021. Tested positive for kratom on May 4th and 16th, 2021. And then finally, the addition in the intervention order, number 3, that he successfully completed the intervention plan, including abstaining, using drugs or alcohol for a period of 1 year. And that indicates that he was arrested. He stated he had drank 3 beers earlier that day. He was also found to have a cooler with no open beers inside. And he also, August 30th, tested positive for alcohol at the Hyde County Probation Department. That notification was by Mr. Argina. The court notified Mr. Bruce of this alleged violation and set the matter for hearing today. At this point, Ms. Wood represent him, and Ms. Wood, you had an opportunity to review these allegations with Mr. Bruce.
I have hearing.
Is he going to want to have a hearing, or will do some admission?
He is prepared to admit to them.
Right? Mr. Bruce, your intervention program, you pled guilty, and then you were put on a supervision for a period of 2 years in order to complete the intervention plan, which required that you abstain from using alcohol or drugs for a period of at least 1 year. And also posed other conditions that are standard. Now, you have a right to have a hearing, and that's why we're here today, and which the state would have to present evidence to the prosecutor's office and witnesses, presumably Mr. Argina, maybe others, as to what they say happened. You have a right to have your attorney cross-examine those witnesses, try to bring out evidence to help your side of the case. You have a right to testify on your own behalf or present any other witnesses you may have on your own behalf. Now, in the event that you are found to have violated these conditions, whether you have a hearing or whether you admit to these violations, then what will happen is you will be found guilty. Originally, you were not found guilty. The court accepted your plea, held the case in advance or stay. So then you'll be found guilty, and then the court will order an updated pre-sentence report, and then we'll set a hearing date for sentencing. And at that time, you could be sentenced to a term of imprisonment of between 6 to 12 months, and fined $2,500. You could also have your license suspended for 6 months to 5 years. Then don't have to send you to prison. I could instead sentence you to control for a period of 5 years, which would be probation, but much more intensive, much more strict than what you've been in. And that could be for a period of up to 5. But if that means you would go to prison, but if you violated those conditions, then at some point then you could be revoked, and then you could go to prison. Now, do you understand the allegations?
Yes, sir.
Do you understand your rights to have a hearing?
Yes, sir.
Do you understand the consequences of admitting to the alleged violations?
Yes, sir.
Has anyone promised you anything or threatened you in any way to get you to make this submission?
No, sir.
Are you doing this voluntarily?
Yes, sir.
Right, then do you admit or deny the allegations that I just read to you?
I admit.
All right. Court then will find the defendant guilty, terminate the ILC, set, headquarters updated PSI, including a, assessment for substance use disorder and or mental health. Set the, sentencing date. January 5th at 9 a.m. So Wednesday. All right, Mr. Pearson, you need to see Mr. Argino over here to make an appointment to see the PSI officer who writes the report. And also, it would not be a bad idea for you to get into some sort of residential treatment, I think, or at least be assessed to that. I don't know, but given your history, it would seem that that may be in order unless you're already in some other program of progression. Are you in any treatment right now?
Through Claremont County, I've been told to go to Brightview. I'm trying to get the insurance figured out. My next appointment with my
That you live in Claremont County?
I'm sorry?
Do you live in Claremont County?
No, I do not.
Where do you live?
I like Lynchburg.
Well, I want you to assess through FRS. I would prefer you do that.
Now,
Brightview has a, they mostly what they're doing, as my understanding, is MAT. And, I don't know if you have an opiate addiction, of course, MAT does work for alcohol. And, well, let me back up. I'll have Ms. Sturgill make that determination. She may decide that Brightview is the right place for you to be assessed. Ms. Sturgill will make that, set up an appointment with Ms. Argino and give you some time for you to get with her. And then you also need to see Officer, Cole.
I do have one question.
Pardon me?
If I get into FRS, would that be able to work for Claremont County? That would be easier for me.
I don't know.
Okay.
It ought to because it's local.
Okay.
And it's a lot easier for people to get treatment locally. But, I can't answer that because that would be up to that judge down there. What's the charge? I don't know.
No, what you just read off the,
Just a municipal court. Okay. Oh, yeah, the OGI, yeah.
yes.
Well, I don't know which is some sort of alcohol program. It says you had an ODI. And that may be what's happening. And again, it may be that MAT is appropriate because medical assisted treatment, boxing, or subject acts, or withdrawal, that works on alcohol. It helps prevent the cravings and the gratification from getting alcohol. But again, I don't know if that's appropriate or not. I know Brightview, that's what they do. And be just real frank with Brightview, we don't have a very close relationship with them. They communicate when they're asked to, and so we prefer to have other providers that we are more familiar with. But if it's, again, I'll leave it up to the professional probation department and Ms. Sturgill, who's the clinical program director there, as to which, where you should be assessed and what treatment is best for you. All right. Anything further? Get your sign notice from Inlet and Ms. Argina, and ready for your appointments in the probation.
Thank you, Your Honor.
Thank you. Okay, do you have the envelope with?
That's, I think it's, thank you.
Yes, one last thing. Is that a in person or Zoom? Private third and Zoom. Zoom, okay. Probably got an ILC as well. Request. All right. Go ahead and see what I. Case number 210152, State of Ohio versus Ryan McClure. You're Ryan McClure, appearing on the screen marked Alexis Lisa.
Yes, sir.
Okay, and where are you, Mr. McClure? Okay, great. I figured you were, but I wasn't sure. All right, Mr. McClure, this hearing being conducted by Zoom, and Mr. McClure's attorney is Dennis Kirk. He is on the call, and also Assistant Prosecutor Kane on behalf of the state. The defendant is charged with receiving stolen property of fourth-degree felony. This is a first-degree trial, and I'm sure we only have a trial date. Final for trial is December 15th, trial date January 11th. Now, I've received a motion for intervention in lieu of conviction and stipulated questions. And I'm going to hold this up to the screen. This is the second page of stipulated questions for intervention. And that's your signature there on the dated 17th of July there. Next, Mr. Personally. All right. All right, so are all the answers to these questions accurate?
Yes, sir.
All right. Well, in court will order that the defendant be assessed for intervention in lieu of conviction by the probation department. And you'll need to call them after we get done here. What's that number been? 840-0136? No, that's a pharmacy.
1802
uh,
0840.
What is it?
0840.
0840? Okay, is it 393 or 840? You don't have to, do you, Mr. Blair? Okay, that's it. I couldn't remember if it was 840. Okay, so here's the number. 937-393-0840. And you'll need to talk to Officer Arajima, and he will talk to you about that. And Officer Fulton will be the one who will set up an interview with you either by Zoom or by phone. And then you'll need to sign a release of information there for use reentry to send us the confirmation that you're in the program, that you're compliant, that type of thing. And then, so we'll set the hearing on this for today's 22nd of January, or November. So we're going to set this for January the 5th at 11 a.m. And we can do that by Zoom. Assuming everything comes through, it's okay on the report, we'll go by Zoom. Okay, anything further with council?
Just so we're clear, is the December 15th final recall vacated?
Oh, yes, thank you. Yeah, the 15th will be vacated, so you don't have to worry about that, Mr. Clerk. And thank you, Mr. King. I'll note that on my notes so the assignment commissioner can vacate the pre-trial on 12/15.